following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the role of a prosecutor in Sri Lanka. The Attorney General's office, which executes the role of the prosecutor, is provided with an immense responsibility, especially in criminal justice. This role has evolved with time alongside the influence of many legal systems. Do we as a country need to rethink our approach to prosecution? How has this role developed and where are the loopholes? Should the Attorney General's powers be expanded to cater to a wider array of crimes? Welcome to Law, Land and Liberty. We are keeping with the promise of bringing in a contemporary legal topic and breaking it down for our viewers. Now today's topic is something that I've been wanting to discuss for quite some time, and that is the role of a prosecutor. Something that involves almost every individual within our country and almost every field rather. And something that we need to get a breakdown. And we have with us an individual who has been within this program before and someone who has given some of the best breakdowns I have seen within this program also, Reverend Dr. Noel Dias. Thank you so much, Father, for joining us today.
Thank you.
Reverend Doctor is a lecturer at the Law College of Sri Lanka. He's the founding editor and consultant to the Sri Lanka Journal of International Law, published by the Law Faculty of the University of Colombo. He's also a chaplain to the Sri Lankan Army. Now, Father, as we proceed within this topic, what we generally do is we give a breakdown for our viewers, and that is exactly what I will do now so that it's easier for everyone who is listening to follow. Firstly, we are going to talk a bit about the objectives of the Attorney General's office. Secondly, the pre-trial powers of the prosecutor. Thirdly, the international norms and standards that are involved in this topic. And finally, reform and development.
Hello, my name is Savishka Samratunga and I just finished my A-levels. My question for you is about the mandate of the Attorney General. What are the statutory objectives of an Attorney General's office in Sri Lanka?
All right, Father, let's directly get into the topic. Thank you so much once again for joining us.
Pleasure.
Father, now the role of a prosecutor, a very broad subject, and some would say even a sensitive subject in certain instances.
Correct.
And within the first segment, I want to discuss and get a breakdown of the office that is involved,
yes,
which is the Attorney General's office, the Attorney General's department.
Yes.
I think there's a lot we can talk about in terms of the parallels that can be drawn with other countries and what other offices also stand, basically when it comes to English law and the United States, for example.
Right.
Father, where do you begin when I ask you the question of what the key objectives of the Attorney General's office is?
Then I have broken down into two main segments.
Yeah.
The preliminaries.
Yeah.
The preliminaries involved about the two kinds of processes, the criminal processes that are involved, which is inquisitorial and adversarial, what it means. Then the history of the Attorney General in Sri Lanka, and like what we said, the objective, the tasks they assigned to the Attorney General.
Yeah.
That will form the first lot, which is the preliminaries. Then of course the more specific one is the role of the Attorney General in Sri Lanka, like what we said, from a comparative perspective.
Yeah.
We will discuss the international standards and how it had been applied to Attorney General in Sri Lanka.
Yeah.
And of course, like what we said, we'll take on some of the suggestions, how we can improve this particular institution, Attorney General's role.
Father, I want you to proceed on that in terms of history. If we draw from history pertaining to how this office took its transformation, the evolution process that took place, I think that will give good context to our discussion.
Prior to that, as I said, the two procedures involved. Therefore, there are what we call the inquisitorial system, which is adopted by the civil law countries, that is the continental Europe, leaving out England and Ireland. So the inquisitorial model, and the other one is the adversarial model. Yeah. That is what we adopt the common law, and Sri Lanka and England and America falls into this category of adversarial process.
Yeah.
So in the case of the inquisitorial system, there is an independent judge. Yeah. So unlike in the case of our Attorney General, he is a partisan person. The inquiring magistrate will take, like in France, he is called the juge d'instruction, which is the inquiring magistrate. And therefore, he is an independent person, and the task of his is to gather evidence to proceed with the trial. So therefore, there is much less involvement like in the attorney general, in the common law tradition, where it is pitted. Adversarial means there is like a game, like a football game or a cricket match, you know. There is the prosecutor on one side, then there is the defendant, the accused on the other side. There is an independent judge. He is like an umpire. He doesn't get into the fray, you know. He's just see that the rules are observed, and eventually, of course, he is the one who gives the judgment. So this is where, some of our problems also will come, because the Attorney General tends to be partisan. In the sense, you know, therefore, sometimes there are instances where somehow they want to get a conviction, and that will leave the accused in a very pathetic situation. So that is with regard to the procedures involved. Then about
just to get a clarification there itself, Father, the objective in that scenario for the Attorney General, for the prosecuting party, is not to get a conviction, but rather to explain the entire situation.
And also to see that justice is done, you know. So now, for instance, just for the sake of securing a conviction, you can't sort of hide facts or make misstatements. No. He also must adopt certain amount of impartiality, you know. Like, of course, he is not impartial to the extent that the juge d'instruction in France or inquiring magistrate in the continental system, but at least he must honor and respect the rights of the accused.
Because they follow inquisitorial system in that instance.
In continental countries, they follow the inquisitorial system, but in the common law countries, which is England, America, and the colonies, we adopt the adversarial system.
If you may continue.
Then we come to the history of Attorney General in Sri Lanka. You know, actually, in the old Sinhala system, we don't find kind of an organized system as such. So for the first time in the Dutch, under the Dutch rule, that we find what we call advocaat fiscaal. Advocaat fiscaal is the rough equivalent to the Attorney General. But of course, the difference is in advocaat fiscaal in Dutch times, you know, he had many roles to play. Apart from being the prosecutor, he was like the finance minister, like the auditor general, several functions. Then what happened is when the British took over, this advocaat fiscaal in 1834 was named as the King's Advocate. Then 50 years later, this King's Advocate was changed to Attorney General. And our first Attorney General is Francis Fleming. He is the first Attorney General in Sri Lanka. So that was during the colonial period. Then during the independent Sri Lanka under the 1948 Constitution, the Attorney General role is very clearly defined. You know, he is not a political figure. The Minister of Justice is a political figure, but Attorney General is maintains certain amount of independence. And also he's different to a permanent secretary. So therefore his role is somewhere in between a political and a state officer. But essentially he is a state officer. So that was under the 1948 Constitution. Then in the under 1972 Constitution, Attorney General was given an additional function. Apart from what was happening in the previous regime, he became, he has to see the constitutionality of the bills. So therefore, the Attorney General, you know, has to do that function.
That is, even if they are not debated, or as in, should there be someone asking for whether there is a constitutionality, or
right at after the bill is drafted by the legal draftsman, you know, if he finds anything, you know, irreconcilable or unconstitutional, he has all the right, because he is like the
he meaning the Attorney General.
Key person who will see to the address the court with regard to the constitutionality of the bills. So the situation is much the same in 1978 Constitution. You know, like what was in 1972 was also sort of adopted by the 1978 Constitution. But thereafter, under the 1972 Constitution, you are familiar that what we call the administration of justice law was the law that governs criminal prosecution. But after the 1978 Constitution, they adopted, they passed the legislation Procedure Code Act number 15 of 1978. That provides for the functions of the Attorney General with regard to criminal prosecutions.
Okay.
Yeah. And under that particular legislation, that Criminal Procedure Code Act, there is the offences are divided into what we call the indictable offences and non-indictable offences.
Right.
So therefore, the Attorney General is the person who files action on an indictment.
Right.
Whereas, like a non-indictment where the police or even a private private prosecutor can also bring up action before a court.
Right.
So therefore, under the 1978 Constitution, he has to take care of the indictments, which involves major offences.
Right.
And Section 396 of that Act, also provide, this is where the controversy lies, where he has what we call the power to give, declare nolle prosequi, two Latin words, which means to say that he is not going to proceed with action.
Okay.
So that is provided for in Section 396.
Is there a reasoning, as in, is there some framework where he has to follow in order for some action to not be proceeded? How does that work?
Actually, this is where he is like virtually has a monopoly.
His discretion.
Yeah,
right.
Absolute discretion.
Okay.
That is where we will be coming into it when we are discussing issues. But he is the one who decides whether a particular action will have to go ahead or not.
Okay. Okay.
So, Section 396 provides for those indictable offences and non-indictable offences.
Father, you may continue also. In the meantime, if you could also touch on the aspect of the relationship between the Attorney General and law enforcement officers like the police and all of that, if you can give that establishment. I think please continue.
Right. Thank you very much. Then
no
you are a law graduate, so therefore you know what was missing. Yes, in fact, though Attorney General is the superior officer with regard to indictment, the groundwork is done by the police or the other state officers who will have to do the inquiry. But therefore, when the evidence is brought forward by the police or the other state officials, then he has to make an assessment whether to proceed and to how to frame the charges, which is the indictable offences or non-indictable offences, and whether the action will have to go ahead. He is the final arbiter on that issue.
Right.
Then with those historical notes, then we also mentioned about objectives.
Yes.
Objectives, the task assigned to the Attorney General, he is the foremost and primary prosecutor.
Right. Father, sorry to disturb you, but where is that, where is it through common law that they have identified the objective?
No, Constitution has provided for that.
Okay.
Constitution has provided for. Of course, there are certain practice rules that come, but these are sort of, provided for in the Constitution.
True. Okay.
Yeah, foremost and primary prosecutor. And also he is the foremost legal officer, both in the private bar as well as in the public bar. He is the foremost officer. And he is the leader of all lawyers in Sri Lanka. So we come under the private bar, and he is also the boss, the chief of lawyers. And also Attorney General is the one, he becomes a necessary party. In the event, there is a case action filed for or against the government, Attorney General must be made. It's called a necessary party in criminal action. Right. So those are the tasks that are assigned to the Attorney General.
Right. Father, I think a very comprehensive first segment. I think we can really move into our second segment as well, based on the foundation you have established there. We'll take a very short break. We are in conversation with Reverend Dr. Noel Dias. We are getting a very good breakdown of the role of the prosecutor. Stay with us on Law Line and
Hello, my name is Mendes and I am an ICT student. My question is about the pre-trial powers of the prosecutor. In the fields of investigation and filing charges, what are the key powers provided to a prosecutor in our country?
Welcome back to Law, Land and Liberty. We are in conversation with Reverend Dr. Noel Dias. We have passed, I think, a very important segment where you gave a very important breakdown of what exactly the role of the Attorney General's office is, and we can really base our discussion on that. Now, Father, for this segment, the pre-trial powers of the prosecutor is something that I want to discuss. The discretionary powers, I think, what the prosecutorial discretion that is awarded to the prosecutor.
Yes.
That is, how exactly do you approach that aspect? Because a lot of people would not be clear about the authorities that have been given to the prosecutor in those scenarios.
Yes. With a brief introduction back again into the discretionary powers, we go to the international standards, That involves the two main international covenants, that is the ICCPR, which is International Covenant on Civil and Political Rights. Article 14 provides for the right for a fair trial.
Okay.
And under that, 14 subsection 3 deals with what we call the pre-trial investigations and also determination of, and that is where the Attorney General will come under ICCPR.
Right.
And similarly also we have the, world-reputed convention, the European Convention on Human Rights. Article 6 deals with fair trial, and 6.2 deals with the pre-trial provisions and also how it has to be expressed,
Okay.
So that will be the international standards, and with that we will come to the application of, the role of the Attorney General in Sri Lanka proper. And we will also proffer certain suggestions, for, of course we must, right at the outset, I must compliment the role of the Attorney General because he has so many functions, but at the same time we are also interested in the welfare and also see that justice is done. So I would like to proffer certain suggestions, because there are certain negative orientations that has taken place, especially with regard to the pre-trial determination of the Attorney General.
I want to give you a lot more time on that, Father. That's why we'll separate this entire segment on reform and where you think the developments should take place. But as you were continuing on the pre-trial powers, what exactly are those?
So as we said, the role of the Attorney General will come, after the investigations are done by the police officers or the state officers, then he has to make a determination whether the action will have to go on or discontinue proceedings. So the discontinuance of the proceedings, what we call nolle prosequi, that is a two Latin word, nolle prosequi means not to proceed, would be permissible under these following circumstances. If the offence is relatively small, sometimes out of the facts you can draw up several offences, So if certain offences are so minimal in favour of giving priority to the major offences, he will drop the charges against the minor offences. When the suspect is dead, though, the offences are time barred. That's another situation. So we have called prescription. So if the accused is dead, you can't proceed with the action. Then of course definitely action will have to be called off. And also sometimes it happened that it's time barred, past the limitation of time. In Sri Lanka it is normally 20 years for an offence, but for murder there is no time limit. So when those that is second situation where discontinuance of proceeding can take place. So having stated that, we will come to the international standard.
Father, before that, if I could just get a small clarification, in the event of a lack of evidence or an issue with the investigation process, does the Attorney General get to give his opinion about it? Can he direct the authorities again?
Absolutely. He is, as I said, when we discuss about the tasks of the Attorney General, he is a primary and foremost prosecutor.
Right.
So he has complete authority over the prosecutions.
Right.
So if he finds that the police has not done his job, we can ask him for further inquiries, so that facility is there.
Okay.
So now with that, we will come to the international standards. So under international law, as I said, under the European Convention on Human Rights and the ICCPR, where the prosecutor has trespassed or sort of crossed beyond under which the prosecutions are not proper. So first one is when the Attorney General declares that a suspect is responsible for criminal action prior to a court adjudication. So he presents evidence, all right, but it is not for him to say whether he is guilty or not, that he presents evidence, so therefore he can't advance, prejudge a situation. Then the second one, statements of Attorney General leading to misrepresentation. So as I said, his task is not to somehow secure conviction, no, to see that the justice is done. So if there are, he must refrain from misinterpreting evidence, which sort of leads to the lack of, loss of innocence on the part of the accused. Then this is important for international law, is what called disguised convictions. Under the guise of conviction, the prosecutor want to extract evidence. The landmark case is Minelli versus Switzerland, right. What we call disguised conviction, where in this case the applicant, a journalist, he was a journalist, it's in your same year as yours, published an article accusing defendants of fraud. So after this, the allegations had been made, then the prosecution was time barred.
Okay.
So we said one of the legitimate instances where they can discontinue prosecution when time barred. But in Switzerland, they have given, even though the prosecution fails, he can order the payment of costs.
Okay.
For the cost of the proceedings.
Sorry.
And 1/3 of it has to go to the defendant.
Right.
So now, and in this particular case, because the law provided for payment of compensation even in the event of the discontinuance of proceedings.
Okay.
And the European court found, that is called a disguised conviction.
Okay.
So what the court did, imposing. The reason the court gave was that in the event, if not time barred, he would have found guilty.
Okay.
So already the prosecutor has prejudged the situation, which is against the international standards.
Okay.
So disguised convictions are barred. The international human rights law doesn't permit the use of disguised convictions.
Father, if I may, just because we want to give an entire segment to international norms and standards also, if you can draw a parallel between that and what's present in Sri Lanka, where is that applied here directly?
Of course, that is what we are saying. It is an international standard. Our Attorney General also must observe that standard. So disguised convictions, even in Sri Lanka, would be illegal, a violation of human rights.
Right.
Then I also take one or two other cases, what they call Funke, F-U-N-K-E versus England. This was a case where the sales representative whose home was searched is also a type of a disguised conviction, and not finding the documents, Funke was fined.
Okay.
What is the reason? Because the law provided that state, he sort of, not cooperating with the state officer.
Yeah.
But actually this conviction was, the fine was made in order to extract some evidence which the police was not able to find when they visited home,
Okay.
So that also in a way amounted to disguised conviction. And the other thing is also where the right to silence is a very important safeguard for the accused, In international law, they have what we call the accused has the right to silence and to refrain from incriminating themselves.
Yeah.
So this kind of imposition, the court found, European Court of Human Rights in Strasbourg, found that the state has violated his Funke's rights to fair trial.
Right.
So that
and even if I'm not mistaken, Father, we have that provision within our criminal code as well.
Absolutely.
To not incriminate oneself.
Not to incriminate, and also right to silence. Both of them are incorporated into our legislation. Yes.
Right. Father, if I may, just to push back to something that we were talking initially about, I think you have mentioned this also about the Supreme Court rules on professional conduct for attorneys of law.
Yeah.
And you mentioned that the Attorney General in that scenario has certain provisions that have been highlighted as these are things that need to be highlighted not only by the Attorney General but both parties.
Thank you very much. Yes.
How do you approach
We'll come back to that, because when we are discussing the role of the Attorney General in Sri Lanka, we'll come to the Supreme Court rules of 1988, number 52.
Right.
The Supreme Court rules provide for the functioning of the Attorney General. We'll come to that.
Right. No, I just wanted to touch on that now, Father, because I want to give more time for the international norms.
Okay.
Is there a possibility to do that, or do you want to continue? Sure. You can pick.
So that is now we had dealt with Minelli's case, but an example of a disguised conviction, and Funke's case where the right to silence and right to non-self-incrimination had been violated. So there's another instance, of course, where the court found that the state was acting properly. And it's called Delcourt versus Belgium. Delcourt versus Belgium. In this, in Belgium, the Procurator General is like the equivalent of an Attorney General, but you really remember he's also independent, like an inquiring magistrate. You know? Right. So Procurator General acts at two levels.
Okay.
First, at the investigation at the original court, he acts as an investigator.
Right.
And subsequently, in the Court of Appeal called Cour de Cassation. Cour de Cassation is like the highest court in Belgium. Then he functions as an advisor to see whether the judges uphold the law. And so, in this particular case, though he did both functions, he was appearing at the original court and also the Court de Cassation. The Human Rights Court didn't find anything objectionable, because he always, not only he's taking care of the interests of the prosecutor, but there had been instances when they studied the procedures, real action in Belgium. They found, that the Procurator General is also taking care of the rights of the accused had been also protected. So in that case, in Delcourt versus Belgium, Attorney General, the Procurator General was acting in fairness to fairly.
Father, before we proceed, I think we have a lot more to continue on that regard.
Yes.
I want to take a short break and we can come back and we can discuss, I think, further continue this discussion on the international sort of like common law elements that are in play. You're watching Law and Liberty State.
My name is Sabi Jeffrey and I'm a history tutor while being a commerce student. My question is about international norms and standards. Does the Attorney General's office have to follow international standards in the discharge of relevant duties?
All right, welcome back to Law, Land and Liberty. We are in conversation with Reverend Dr. Noel Dias. Father, I think two very important segments that we passed, and we did approach this topic within our previous segment as well, which was on international norms and standards that need to be followed.
Right.
I won't let you to continue with the sort of case law that you were mentioning, and then we can move on to other aspects.
Right. We touched upon Mahieash case, in the Funker's case, and also Delcourt. And this one, the case is very similar. The facts are very much similar to Delcourt. In Italy, called the Commissione della Legge, which is the equivalent of the Attorney General, the Procurator General in Belgium. But here, in this particular case, he acted as a Commissione della Legge, as a commissioner. And subsequently, 2 years later, he also came as a judge in that particular case. Then the court, European court, found they were mixing up the discretionary powers with the judicial powers. And they said that was in violation of international human rights law. So that is a tierce case. You can't merge the prosecutor power with the judicial power. It has to be separate. Then we come to the final case that on international law proper, the Can versus Austria. In this particular case, the applicant complained about the prohibition of unsupervised interviews with his counsel. In Australia, Austrian law provides for a state officer to be present when the accused and the suspect and the counsel are present. And the European court found that that is completely unfair, because the accused will not have the opportunity to mount a valid defense, because everything will be reported all, but the secret that has been given to the counsel will come out. So
that is when the counsel and the accused are discussing in front of a law enforcement officer.
Austria provided for the presence of a law, like police personnel to be present when the interviews are going on between the accused and the counsel. So that the court found. So therefore, you can't sort of we have come back to the same right to silence and non-self-incrimination, and also when the state officer is there, he will not be able to be free to communicate his defenses properly. So those are the main cases that touch upon international law. But we will come also to, there's a Sri Lankan case that is under the ICCPR.
Yeah.
We'll come to that Victor Evans case.
Yes.
Yeah.
I think we can discuss that right now, Father, because I think there was a comparison that you made with another journalist's case also.
Right. Yeah.
So if we can continue from there.
Right. Yes. Actually, so now we just briefly mentioned about that 1988 Supreme Court rules, no?
Yes.
And the Supreme Court rules provided what we call the AG must cite cases and statutes both for and against the accused.
Right.
One of the duties is entrusted by the Supreme Court rules.
Okay.
He must assist the court in determining errors of facts or law. So that's also he should be present with justice is the norm, because he is somehow not to sort of get a conviction at any rate. No, justice must be meted out. And if there are mitigating circumstances in favor of the accused, then also he must apprise the court of those mitigating circumstances. If there are errors and mistakes made by the defense counsel, also he has to bring it to the notice of the court. So, therefore, our law is so good in that sense, but unfortunately, between the law and also the enforcement of the laws, there is a bit of a gap, So, and other one is sentencing policies must be reported to the court by the Attorney General, sentencing standards. So, we come to that level. And the AG should be present at all through the proceedings. So, he can't sort of miss out any part of the proceedings, so that otherwise he will not be able to get a full picture of the case. So these are the rules that are given in the Supreme Court rules of 1988. So with that, we will come to the present day performance of the Attorney General.
Yeah, I think that's exactly where I want to go, was the practical aspects of it, Father. Now, for me, if I were to listen to it as a layman, even the scope is extremely vast for the Attorney General in that regard. And
very, very vast.
And that don't you, I think I don't want to move into the reforms aspect, but how does the current law exist in a way to not overwhelm this specific office or the specific individual in charge of that office? How does that work?
Yeah. So as I said right at the outset, my negative comments must be seen in the light of the, like what you said, the tremendous task that I entrusted to the Attorney General, and he does it quite well. But at the same time, we are also interested that justice is meted out to the accused. So therefore, the deficiencies and shortcomings that had come, right? Almost from the inception of this English legal system. We are inherited English legal system, and the Attorney General had been playing a crucial role. So there is a case that I would like to cite is Victor Evans case. It's also ones that we have dealt with so far was the European Court of Human Rights. The
international cases.
Yes. And this one is from the Human Rights Committee of the ICCPR. And so in Victor Evans case, the Human Rights Committee found, now in this, Victor Evans had been charged with several indictments, and none of them were sort of, they have finally made determination. And the court said this was a violation of Article 14 subsection 3 of the ICCPR, which provides for the pre-trial safeguards for the accused. And the other thing that we hopefully we'll have to talk Monday about the law's delays. Unnecessary delay would be in violation of the international human rights standards. Then with that we will come to, there are, as I said, we have given the positive side of the Attorney General, but also there had been some areas where the Attorney General's role must be improved.
Right. Father, before I need to interrupt you there, because I need to give some separate time for you to discuss all of that, because if we can go into details about the reformations, it will be very important to our viewers. Just on this aspect itself, Father, something I want to clarify, I think, because a lot of laymen also watch this program, they would want to get an understanding of, okay, in those instances, is there a process for either the layman or an individual who is accused to question maybe the direction that the Attorney General has been taken? Is there a process where that can happen?
Danidhu, you have really prevaricated my conclusion. The whole problem is that the Attorney General's discretionary power is almost unreviewable. In Sri Lanka, we have not seen that. And that is where the danger lies So when we come to this, we will
Reforms.
go to England and also America briefly about the role of the Attorney General.
Yeah.
So, but now the issue is that his discretion is almost virtually absolute, you know. So that is where I am going to cite some of these instances. You know, it had been from this the international and independent group of eminent persons where Justice Bagger was involved in 1980s. Yeah. Where, you know, there was Udalagama Commission was appointed to inquire into the 17 NGO personnel who had been killed, you know.
Right.
And therefore the IEG, that is International Eminent Group, found we are concerned about the role of the Attorney General. So therefore in the Commission, the Attorney General Department took care of the presentation of evidence, you know, as a legal counsel to the Commission. So Attorney General did the function as a legal commission, legal officer in the that particular Commission inquiry. The Attorney General's Department is the chief advisor to the government of Sri Lanka. So when we started off with the task, he is the chief government officer in prosecution. The Attorney General's Department have been involved in the original investigations into the cases subject to further investigation by Commission itself. So therefore initial investigations was done by, of course, through the police. Attorney General was the key person who governs investigation. As such, the members of the department may find that they are investigating themselves, you know. So the very people who, you know, who provide evidence, made investigations, they also become at the level of determinations, you know, become a judge in that sense. Furthermore, it is possible that they are called as material witnesses before the Commission. So I mean, he had been running the whole gamut of activities, right from the investigation also to the presentation of material evidence. Attorney General was involved. We consider these to be serious conflicts. So therefore, this eminent group say this role played by the Attorney General in this particular Commission of Inquiry is subject to conflict of interest and compromise national and international standards of independence and impartiality of the central to the credibility and public confidence of a commission. So therefore, if we act so in a manner that will cast doubt, you know, with regard to his independence and impartiality. That is from this eminent, how to call it, international independent group of eminent persons. That is observation about the role played by the Attorney General in the Commission of Inquiry.
Right. I think something that was very interesting, Father, because I know a lot of people wouldn't have heard of this specific, I think you can't say ruling, rather their opinion that was casted on this. Father, I want to go into the reforms. I think that's where we are heading to right now, where we can talk about the improvements. But before that, we'll take a very short commercial break. Please join us on our last segment as we talk about the reforms and the aspects where we need to develop on when it comes to this subject matter. You're watching Law, Land and Liberty. Stay with us.
My name is Binat Senemiratna and I'm an engineering student. My question is about reform and development. What are the key areas of reform required in this field, primarily with regards to the scope of power provided to the Attorney General?
Welcome back to Law, Land and Liberty. We are in conversation with Reverend Dr. Noel Dias. Father, for our last segment, we wanted to speak about the reform and development aspect, as we just mentioned. I think you were talking about an observation that was made with regards to where the placement of the Attorney General will play a big role, because we have seen, I think, within our country's history, the appointment of commissions every now and then, and a lot of people aren't too aware of their role and how that really is facilitated by the Attorney General or the other way around. One aspect that we did touch on within our third segment was the review procedure that doesn't exist as of now. Is that the key sort of reform that you see is required, or where do we need to head from this?
Before that, in order to come to that conclusion, Danidu, can I also cite some instances from the Human Rights Committee? You know,
no problem.
We just mentioned about now Human Rights Committee provided for two kinds of procedures, what we call private petitions, and the other one is periodically once in 2 years, a country will have to submit a report of the the human rights standards.
Okay.
So this Human Rights Committee in 2012, this is what they found with regard to the role of the Attorney General. In recent years, this is what the Commission said, in this report, Attorney General has failed to properly investigate and prosecute state agents involved in human rights violations. So the Human Rights Committee itself says, that Attorney General has failed in this regard. Provided legal advice to the President and the government to avoid accountability. In that also they have failed. Use his discretion improperly to withdraw and transfer cases.
Right. This was during which time period?
2012.
2012, okay.
Yeah. Used its powers improperly under the emergency laws to deny bail applications.
Okay.
Stymied ad hoc efforts at providing accountability through commissions of inquiry. Okay. What we have already mentioned in Udalagama Commission. Each of these actions has strengthened the culture of impunity in the country.
Okay.
So what will happen? This will sort of lead to impunity in the country. The failure on the part of the Attorney General to see that justice is done. These developments are not just alarming because they violate international law and standards on the conduct of judges and lawyers. The failure of the state to provide justice and accountability means that individuals have suffered seriously.
Yeah.
So therefore, if the Attorney General doesn't do his job properly, what will be happen? The innocent people will get suffered. Exactly. So this is not my word, it is the writing of the Human Rights Committee on the periodic reports.
Right.
Having said that, then also this same report, this report examines some cases, they give instances. They are just having given the conclusion, but they also give instances, where on the part of the Attorney General, that justice has not been meted out. The cases discussed span several decades and implicate several governments.
Okay.
They include the killing of 5 students in Trincomalee in 2006,
right.
the Action contra la Femme massacre in Mutur in 2006, the Bindunueva massacre in 2000, the Mailanti case in 1992, the Richard Soisa's case in 1990. So these are some of the instances where the Attorney General has failed to proceed with action.
Right, right.
And other cases focus on improper acquittals. So one, the failure is on the part of the convictions, and the other one, the failure on the acquittals. Other cases focus on improper acquittals of state officials under the Convention Against Torture Act of 1994, including Gerard Perra case. I'm not too sure, it's a person from Handale,
Right.
It was completely concocted charges, there is Gerard Perra's case, and Nandini Herat's case in Payagala in 2001, Lalit Rajapaksa's case in 2002. This report also includes an analysis of 4 cases in which state agents were held accountable for serious human rights violations. So that is where, the Attorney General will have to take a price of the situation. That, as I said right at the outset, we honor and say that the Attorney General is doing a tremendous lot of work.
Yeah.
But in these instances, he has to work out towards an improvement.
Right.
And that is where we'll come to sort of make a comparative standard between England, and because we are inherited English legal system, and also they have gone a step forward, but we are still lagging behind.
Yeah. Father, just to push back on some things that you were mentioning with regards to that, can we really pin the blame in those scenarios on the Attorney General per se? Or are there other elements such as the law enforcement officers also that we need to take a look at in these scenarios?
Actually, that's...
what are your thoughts basically?
That's very important case, because the situation, the political will on the part of the ES. So this is where the integrity of the Attorney General will be at stake. Yeah. If he sort of submit itself to the political pressure, So I know it's not only he, but of course it's the system. We have a kind of a system change,
Exactly.
And that's why we are coming to that when we are discussing our reforms. So because as of now, the Attorney General's discretion is unreviewable. But we mentioned Richard de Soisa, I'm sure you would have known about it. He was killed by the STF, and then the police didn't sort of proceed with that. Then his mother filed action, as a private plane against the police, the torturers. And what happened? The Attorney General at that time, they took over, because we say he is the first and foremost prosecutor. So even he can take a private plane onto him, and what he did was he declared a nolle prosequi. So I mean that will be a complete blatant violation of the human rights standards.
Right.
So that is where we this absolute unreviewable discretion must be curtailed. That's our suggestion.
Father, you were just approaching the comparison between the systems that are followed in England, maybe even the United States. I believe it's the Crown Prosecution Service that functions there.
Right.
Yeah.
Yes.
What are the comparisons that you make?
So in England, the situation is that that the Attorney General is a political person, he's an elected member. Then of course that is why in 1985 there was what we call the Prosecution of Offences Act of 1985.
Okay.
Then they instituted what we call the Director of Public Prosecutions. So the two officers are different.
Yeah.
And the task of the DPP is to see to the prosecutions, and also
what are the lessons we can learn from that? Yeah.
But we have to do also to adopt something very similar, Otherwise, even in these instances, we cite one or two cases to say that this DPP discretion is reviewable. In England, there was that famous instance of this Lapid and O'Brien, two black people were killed, in police custody.
Okay.
And at the end of it, the commission recommended, that the discretion of the DPP must be subject to judicial review.
Okay.
And these are the cases in what we call R versus DPP in 1995, where the Court of Appeal confirmed that the exercise of prosecutorial discretion not to prosecute was subject to judicial review. Okay. So therefore, that possibility is there in England, but actually we don't have the differences of the officers like in England. But otherwise, at least minimal level is to have some kind of a supervision over the Attorney General. Right. Rather than having Attorney General doing the whole absolute power over prosecutions, he can assign another institution and department to discern the prosecutions. Yeah.
Father, is there any, I think we are coming to a concluding part of this program.
Yeah.
So the review aspect, I think it's quite clear that is something that we need to develop on, something that's very much required as of now.
Yes.
What else do you think, Father, in terms of the gamut of powers that are awarded to the Attorney General, or do you think if we can really iron out the review aspect, a lot of other issues will also fall?
Absolutely. I think to a great extent, if the review process is brought about now, one instance would be the law's delays.
Exactly.
That we have mentioned under Victor Ivan's case. The police, of course, we do not know which one to be blamed, but of course, inordinate delays, in prosecuting, will sort of, mitigate against the, against the justice demands of an accused.
Exactly.
So yeah.
Father, as a concluding note, I think since you touched on the aspect of the delay of cases, and which is something that we have had to face and we have discussed within this program for quite some time, and specifically when it comes to, I think, not only criminal matters, but like other civil matters as well.
Yes.
What can be done as of now, as a final question, what can be done as of now from the Attorney General's office aspect in terms of reforming the authorities? What can be done to address this?
We can take from the words of Justice Mark Fernando. In the Victor Ivan's case, he wrote an article, the facts we have already stated out. Then he wrote an article to our journal, Sri Lanka Journal of International Law, in 1998. He says it was held that the constitutional jurisdiction of the Supreme Court to grant relief for infringement of fundamental rights by executive or the administrative action must necessarily apply to the exercise of any power or discretion. So the Supreme Court must exercise that kind of power where this discretion is involved, conferred on the public officer by an act of the Parliament. That the absence of constitutionally valid derogation from the jurisdiction, that the Attorney General's discretionary power was neither absolute nor unfettered. So that is what Justice Mark Fernando says. Therefore, though it is said that discretion is not unfettered and absolute, but in fact it is so.
Exactly.
And that when such a power of discretion is exercised in violation of fundamental right, such exercise can be reviewed in a fundamental rights application. So he himself suggests, that provide some relief in the form of a fundamental right application against the Attorney General. Of course, that might be a little too far, going far, but otherwise, even the systemic arrangement is possible, like what they do in England, to have a separate office, for the prosecutions, and the Attorney General's office is different. So therefore, he saw the possibility of reviewing the DPP's discretion.
All right, Father, I think we'll have to end our discussion there primarily because time has come against us as usual. But I think throughout the program, the sort of the density of information that you have provided is quite vast. Reverend Dr. Noel Dias, lecturer at the Law College of Sri Lanka, founding editor and consultant to the Sri Lanka Journal of International Law, published by the Law Faculty of Law Faculty of the University of Colombo, and a chaplain to the Sri Lankan Army. Thank you so much, Father, for joining us.
Narindu, thank you very much. You gave me a chance, to bring this very important topic. I hope Attorney General will take in the same spirit as we have this shared.
True, very true. Thank you so much, Father. All right. The prosecutor, prior to the cloak of authority provided by the Office of the Attorney General, wears the cloak of a lawyer. The former Chief Justice of India, Justice P. Sathasivam, captured the responsibility entrusted onto a lawyer through this quote. As a rule, an advocate, being a member of the legal profession, has a social duty to show the people a beacon of light by his conduct and actions, rather than being adamant on an unwarranted and uncalled for issue. That is all from us here at Law, Land and Liberty. If you had missed today's program, you can rewatch the entire episode on our YouTube channel, youtube.com/AdaDerana English. I'm Daniditha Anwasa. Have a great night.